Everyone. Good morning, everyone. It's great to be with you. For those of you who I don't know, my name is Matthew Branaugh. I am an attorney who has worked for a couple of years now with LegacyWise in a consultative capacity, and it's my real privilege to be with you today to talk more about some of the things that we encounter through LegacyWise workshops, specifically on the legal front. And so, as you can see from the slides that I'm about to share, we are focusing on a topic that some of you have raised in previous conversations, and I know comes up a fair bit, and that is how to address legal questions as a LegacyWise ambassador. And um, I just want to make sure, am I sharing? You're seeing the slides, correct? Great. All right. That's a faux pas. I don't like to ask that question in presentations, but when it's virtual, you got to make sure. So, in any event, we're here to address questions that we come across in LegacyWise workshops. And as ambassadors, you're on the front lines. We want to make sure that we equip you, educate you, empower you to do your work to the best of your abilities and to also understand just the parameters from which you should operate. So we'll just dive right in here. We're going to talk a little bit about how we plan to help you today as a starting point. And really, we're going to kind of delve into four specific areas plus a fifth area that we'll describe a little bit more in a moment. But first, we're going to talk about when questions arise, dealing with the unauthorized practice of law, which is a subject tied to this whole area that we're talking about today with legal questions. What we want to define what the unauthorized practice of law is, when it arises, and why it's really important for you to understand in your role as an ambassador. Second, we want to talk about the legal framework and the rules that govern this area. Third, we're going to talk about penalties and prevention. Fourth, we're going to talk about what are the kinds of things that are still allowed. Um, and then fifth, we're going to do sort of a lightning round Q&A where we'll look at some common workshop questions that come up and we'll just troubleshoot together how we would maybe approach those questions in manners that could be helpful but not necessarily cross any lines. All right, so let's start with the unauthorized practice of law. What is it? Why does it matter? This is what it boils down to. Every state restricts the practice of law to qualified lawyers who meet very stringent requirements. It requires graduating from an accredited institution with a law degree. It requires passing the state bar exam with a score that state says is acceptable. It also requires annual licensing fees, and then it also requires continuing education. In fact, I just sat in on a course yesterday dealing with ethics issues, and this is part of the continuing education that lawyers are required to do every year. Why does this matter? The unauthorized practice of law impacts individuals to the extent that if they cross a line and they begin providing legal advice or guidance when they're not allowed to, they can face civil or even criminal penalties. Uh, Similarly, any organization that allows an individual to do so on its behalf can also face repercussions. So it's a big deal for you all as ambassadors, as individuals who are in these workshops. It's also a big deal for LegacyWise to make sure that we're not enabling you or allowing you or permitting you to do something that would cross one of these lines with the unauthorized practice of law. This is what the unauthorized practice of law looks like from a rules standpoint. The American Bar Association sets model ethics rules that each of the state bars are allowed to reference and use for their own sets of ethics codes. So we'll look at New Hampshire here for a second because that's where LegacyWise is based. But admittedly, all of you are spread out across the country, and so your state will have ethics rules that may look like New Hampshire's or may look a little bit different. It just depends. But typically everybody follows the basic framework that the ABA sets. And when it comes to the unauthorized practice of law, that's typically the case. Under ABA Rule 5.5, there are key prohibitions. First, that a lawyer can't practice where he or she is not licensed. So, being a licensed attorney in the states of Maine and Illinois, cannot begin practicing and advising clients in, say, the state of New Hampshire. That's just not allowed. Now, as always, there's always exceptions and ways to still do things of a legal nature as a lawyer in other states. We won't get into that, but it does require special steps in order to do so. The key prohibitions also include not assisting others in the unauthorized practice of law. So, in other words, I cannot assist non-lawyers in them giving legal advice or guidance in a manner that becomes defined as legal practice. There's also prohibitions from establishing laws without proper admission. This means I couldn't set up a law firm in New Hampshire without being licensed in New Hampshire, and of course, cannot falsely represent that I am admitted in the state where I'm not already admitted, or someone can't represent themselves as being a lawyer when they are not admitted as a lawyer. So those are the basic prohibitions under Rule 5.5 for the ABA. Okay, why is this set up this way? What's the purposes behind UPL? It's really about protecting the public. We don't want to see individuals attempt to provide legal advice when they're not qualified to do so. We don't want to see bad actors represent themselves in one way when they're really not that way and then take advantage of people. And so these rules are designed to try and prevent those kinds of scenarios. They're also set up to really try to provide some consistency so that even though each state ultimately governs the way the practice of law works within its jurisdiction, there's still a little bit of continuity across the states as far as how they approach an issue like this. All right. So we've talked a little bit about what the unauthorized practice of law is, what the rules are, and what the purpose is for these rules. Let's talk a little bit about what is allowed and why things like LegacyWise are allowed to exist and why you all as ambassadors can do the work that you do. It starts with another ABA rule, 5.7, and it talks about law-related services. And here's what some of the key features are. First, that there are quote unquote law-related services that are allowed. Examples of these kinds of services can include things like lobbying, financial advice, or fiduciary roles. These types of operations can operate separately from a law firm or a lawyer and can still be affiliated with a law firm or a lawyer as long as there's disclosure regarding the relationship. And so you might be thinking about LegacyWise, and you'll immediately note Fred Potter, our founder, is a lawyer. You might also note that LegacyWise is oftentimes able to reference legal issues to other lawyers, or in some instances, even an affiliated entity called Just Law that's part of the work that Fred does. And we try to make that disclosure clear up front. If we ever tell somebody you need legal assistance, we have an option that you can seek out. If we reference Just Law, we say this is something that's still affiliated with Fred and with the work that he does as a lawyer, and with things that are still tied to LegacyWise, even though they are not under the same umbrella. The New Hampshire Ethics Committee made an interesting comment about this rule in particular, and it really speaks to, again, where LegacyWise can play a helpful and effective role with the work that it does. The committee commented that a broad range of economic and other interests of clients may be served by lawyers engaging in the delivery of law-related services. So examples that they included could be title insurance, financial planning, accounting, trust services, real estate counseling, tax preparation, and more. So the key here is lawyers who want to set up these kinds of enterprises can do so. They have to make it clear and transparent where the relationship exists and how it works. And it's also important that non-lawyers realize they can also provide these kinds of services, again, assuming that they aren't stepping over the lines and doing unauthorized practice of law types of activities. All right, penalties for UPL. Here in New Hampshire, we have criminal penalties potentially. A first offense could bring a misdemeanor charge, and repeat offenses could escalate to felony status with imprisonment. So it does give rise to some serious consequences for somebody who not only engages in it, but then continues to engage in it over and over again. Civil sanctions can also include fines. They can be up to $10,000, or it could be the economic benefit that the individual derived from the activity, and it could be per violation. So if they've done it multiple times with multiple individuals, whatever economic benefits were gleaned from those activities will potentially give a fine that equates to that amount. And then again, organizational risk also exists here with LegacyWise facing potential institutional sanctions if it were found to be non-compliant with these regulations. So we're going to talk a little bit about here how LegacyWise complies and protects itself and its team. And then we're going to, kind of shift into that Q&A lightning round, look at some scenarios, and then obviously open up here for more questions that you all may have. But let's talk about what LegacyWise does as far as trying to comply with these rules and also to work to help you all do your work well and to keep you protected as well. There's a few different ways that LegacyWise communicates about how it's not a law firm and is not providing specific legal advice. You'll see throughout the website and even a lot of the print and digital materials that we distribute, disclaimers that clarify that there is not a sort of a law firm involved here. This is not a legal entity that's trying to provide legal advice and guidance. We also know with our workshop protocols, we have the verbal disclaimers that we give at the beginning of the workshops. We also have user agreement disclosures with participants required to initial and acknowledge that they understand that this is not a legal situation. We also provide professional referrals. So we have the just law scenario that I've described a moment ago. We also have some other resources we can point to where attorneys in the workshop participants area might be available to help them if they need specific legal counsel. And then we also do staff training. We are doing this program here even today as a direct example of the ways that we try to educate, inform, and equip everyone to make sure they understand how they avoid giving specific legal advice or guidance. And we also, try to encourage, we're trying to give information, trying to give, good direction and pointers. And we can also, encourage you to be okay with saying things like, I don't know, but I will find out, or I don't know, but let's find somebody who can help you. So that LegacyWise user agreement, we'll just point this out very quickly. That you all have seen this. It's a 6-point agreement that has initials that need to be signed with each of them, and then of course the signatures at the bottom. When you focus in on that first one, self-help, this is where we are very specific in helping our participants understand that this system includes information, data gathering, workshops, forums, educational materials, document storage, referrals, and other services, but the use is limited to the participants preparing their own documents, and that they understand that LegacyWise is not a law firm, does not give legal or tax advice, and is not a substitute for such advice, so that they also understand LegacyWise is not my attorney, agent, or advisor, and importantly, that there's no attorney-client privilege that forms in the relationship between them and LegacyWise. So that's the reason that's the first one that's listed on the user agreement. It's really important, and it's a way for us to try and be very direct with participants and transparent so they understand this is the type of situation that we have and this is the type of relationship that we have. All right, let's talk a little bit about what is allowed without violating UPL. We already know law-related services are in fact allowed under the ethics rules for the ABA and the states across the country, including New Hampshire. So these services can be provided, but then even within these services, there are boundaries that need to be honored. First and foremost, we are quick to point out we can give general legal information. There is still an educational component to the work we do. We can talk about estate planning concepts. We can talk about general legal principles. Those types of things at a general level are okay. That's just common knowledge or common information. The line that's drawn is when you begin to speak those concepts directly into the individual's unique circumstances or situation. When you start giving specific advice that's tailored to an individual, that's where we start to see this area become problematic. We can provide these self-service document tools because of the way that the platform is set up. The individual is able to go through and use these tools and templates. They effectively create their own documents with the helpful side-by-side instruction we give about the system to them, but they ultimately are self-serving with the tools that we've provided. Again, we connect individuals to legal counsel, again, whether it's just law or if it's independent licensed attorneys that we can recommend in the specific jurisdiction where the participant lives. Either way, we are happy to try to connect them with that additional resourcing when they, in fact, need specific legal advice. And then lastly, of course, we give that technical and platform support. So we're assisting with the platform, we're helping navigate the tools, we're explaining what the topic is in general, but we're not interpreting anything for them on an individualized basis. All right. So we're going to dive into the lightning round, the Q&A, where we can look at some scenarios and just kind of talk through this basic matrix that you'll see at the bottom of each of these slides. But very quickly, I've just run through a lot of information. I would suspect there could be some questions. So let's just cover a couple of questions that you may have about these concepts in general, and then we can dive into our lightning round. Please, yeah, go ahead and just speak
Oh,
up
sure.
if you wish. Yeah.
I had a quick question. Does it count as a UPL if they do not pay you?
That's a great question. So, in other words, does there have to be a financial relationship in order for it to be considered um, a legal engagement, so to speak? And the answer is it does not matter if there's a financial transaction. You could give somebody legal advice without being paid, and you could still be considered providing the unauthorized practice of law. In fact, in my ethics classes in law school, one of the topics that came up was the proverbial dinner party, where you go and somebody walks up and says, "Hey, I hear you're a lawyer. I have a question for you." And they explain their situation and you kind of give them, well, this is how you should do this, da 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 da. They go and do it, something goes wrong, they come back and they file a complaint with the bar saying this person gave me legal advice and it led me astray, and the lawyer could face sanctions. So it does not require a financial relationship in order for this ethics rule to be violated. It just matters the way that you represent yourself or the manner in which you provide the direct counsel to the individual. Great question. Other questions? All right, well, let's dive into the lightning round. We'll just kind of touch on some themes that inevitably come up. I know in the workshops I've been a part of, these kinds of questions come up consistently. I'm sure these are familiar to you. I would guess you could probably think of many, many more. But the first scenario that we often see is someone asks, should I create a will or a trust? And again, we've got this three-step matrix at the bottom that can sort of kind of guide the way that you can kind of work your way through these kinds of situations. But let's open it up here. How would you handle this question?
Maybe dig into turn the question back and say, well, what are you hoping to accomplish with your plan? And see if you can get more information out of them that might give you a little bit more to go on with what might be guidance or whether you refer them right to an attorney.
Excellent. That's exactly right. Sometimes a way to help give them the direction they need is to help them talk through their situation more. So, kind of posing the question back to them in that manner is a great way to give them that ability to kind of see a path and start to talk through it further. Good. Other ideas.
Well, hang on. You could typically, in all the years of practicing financial planning, people have ideas of what they want to do, but we also have to open doors to help them understand some things that they don't know or they don't see. So typically, when it comes down to will versus revocable living trust, there's um, some good things, some good reasons. Do you want to avoid probate? Do you have the property outside your state of domicile? Like here in Pennsylvania, people have shore properties in New Jersey or Delaware.
Mm,
These types of things, revocable living trust as a tool is going to really be able to help facilitate the settlement of the estate. It's, of course, the specific trust related types. Specific distribution. I've seen revocable living trusts be able to have much better language to be able to allow for specific distribution at much more efficient distribution times. Obviously, probate can take quite a few months. Uh, a trust could be done in a very, very short period of time. So it's just those kind of questions. And I always have that discussion with people. Sometimes it comes down to a simple will, but when we had our seminar about a month and a half ago or something with Fred, he made a comment about we feel that the trust is a superior document with the pour over will, and I think that it's our responsibility, particularly me as a financial advisor, to help them understand the benefits of what a trust can do as opposed to just a simple will.
that's Michael, that's great. That's exactly right. You're talking about again, general kind of concepts, information that pertains to those and the advantages or disadvantages of both without saying specifically for the individual, this is why this is good or bad for you. It just simply gives them the information they need to make what we hope is an informed decision. It's great. All right. Well, let's move on to the next question here. This one, again, kind of goes into kind of some specifics for the participant, talking about a blended family. How should they distribute their gifts fairly? How would you handle this kind of question?
I'll jump in there real quick with this one too, because we're
Great.
part of Kingdom Advisors, the organization that Ron Blue founded.
Hmm.
And he has a comment to this. He says, we don't treat our kids equally or fairly, we treat them uniquely. And I felt that's because every kid situation is different. So we've got a lot of people here, this area of the country. There'd be a lot of people with church related, even missions minded people. So some family will actually be on the mission field with very little resource and very little potential to accumulate. Uh, and that's why there's unique circumstance. And I think that was always great. I just had that. You don't treat them necessarily equally, you treat them uniquely.
That's a great framework. I have not heard that description before, but I like that. I like that a lot.
Yeah, another one that I've used is that equal doesn't always mean equitable. especially when you have one kid that's good with money and one that's terrible with money. You
Mm.
know, what does that look like? So yeah, that's a really good one. And you know, what does fair mean to you? Turning it back on people.
Mhm. Right.
Yeah, the I'm reminded of different of John Adams's father, his will giving equal portions to every son except for John Adams himself because his dad sold 2 acres to help him go to college. Like, and so like 30 years later, whatever, he was still remembering, well, he was the only son that I sold off some of my land to help get him into college. And so that's why he got slightly less than a quarter of my property at the end. And what was the, we don't do it as much this anymore, but in the handling of John Adams' estate, um, his son had to buy his father's property from the estate.
Hmm.
Like, so like his father's books and stuff like that, like he bought his father's library and stuff like that. We don't think of um, you know, paying for a state, but what I run into with a couple of different people that I just have in my mind because they're people I work with or whatever, is there's a very different relationship between the parents and the 5 different children. Not different relationship, but different amounts of giving that the parents have had to do at different stages in life. Because the 3 older kids, they acquired spouses, houses, and children, and the younger kids have yet to be able to leave the nest even after being married. And so and this has gone on for a couple of years, and partially it's not their fault because of the climate and things like that, but it is a consideration at the end, like, well, we kind of room and boarded you for 3 extra years, 4 extra years, like down to even our grandchildren. So that might be something to consider.
Right. Well, and Mikey, one of the things that I'm thinking as you're talking is sometimes great ways to handle questions like these are to use anecdotes, use stories or examples to kind of illustrate, well, here's how sometimes these things can go or have gone for others as far as, these kinds of situations. So it allows, again, the ability to kind of share some insight without necessarily speaking into this is how you specifically should do this. So that's, I think, another approach that you can use in these workshops that can be, still a way to be helpful to the person when they raise a question like this without necessarily, moving into very specific tailored advice. That's good. All right, we'll do one more on our lightning round here. All right, the participant asks, what are the estate tax consequences of owning property abroad? How would you handle this one?
That's a good question for an attorney. That would be my response.
Okay. All right. And tell me a little bit more about why.
Yeah, what kind of property do you have? Maybe I don't know that I dig personally at this point without counsel. I don't know that I'd dig into that anymore. I think I'd shed that one as fast as I could.
Yeah, that's exactly right. Yeah, you're not wrong. This gets into really highly specialized technical knowledge and information. And I can tell you as an attorney myself, I would not answer this question still. I would refer this to somebody who handles these kinds of situations on a more regular basis. I just don't know enough about, first of all, about property ownership abroad, much less property rights in other countries, and then how that translates to somebody, living in the United States and so on and so forth. So, this is a great example of one of those questions where you just want to say, hey, this is where we think you'd be better off talking with an attorney because that's pretty unique or specialized.
And
And
even if it's, oh, I'm sorry.
that's okay. May I answer, may I respond? Because I actually have a situation like this, um, where clients, former missionaries, still actually technically missionaries, owns an apartment in Moscow. So I know a lot about what it is. He knows more about it than we would know about it, and any attorney would know about it. So I don't I don't avoid it. I just understand what the situation is and how that could affect or relates to his financial situation. But I'm not even sure, and I think he understands this. There's not a whole lot that even an attorney might be able to do more than what he actually already knows himself. So I would suggest that if they have something, just understand what they have, get some detail about it, but clearly disclose, we have no expertise in this area. We don't know what to do, but we're aware of what you've got. That's pretty much what I would do.
And what I wanted to chime in on is, I mean, it's slightly less complicated, but I think my response would be the same, even owning property in other states,
Mhm.
because every state has different laws around how
Very
things
true.
are owned. I would take that same stance, I think.
Yeah, you do run into that. It may be a little bit more navigatable because, it's with, it's still domestic, and so it has maybe some familiarity, but you're right. There's going to be different rules, different laws that govern property, and the inner workings with all of that. And so there is a degree of, um, concern about starting to speak too much into the specifics there and telling them how to handle or what to do with it. But Michael, to your point, I think you're raising a good point too, which is we can still find out enough information to kind of give them some general sense again about some of the considerations if they're going with one option or another. I think that's what I'm hearing you say. And ultimately, sometimes the workshop participant knows more about the subject matter than anyone else. And that's where our self-service tools really become powerful, right? Because they can use those tools to set it up the way they need based on the information they already know, the knowledge that they already possess. So it's sometimes a little bit of just sort of like allowing them to let those self-service tools do what they do best.
Right, especially if you know that the situation wherever they're at might be covert, might be cash
That's
or
right.
in their currency or something. We got to stay out of it, but at least I'm aware of
That's right.
what's going on. Yeah.
Especially missionary work where
Right.
their disclosure or the ways that they handle that could become it could jeopardize their
Right.
well-being or others'
Right.
well-being. So
Right.
I think that's an excellent point. Very good. Well, that's the end of the lightning round. Let me just cover very quickly here in closing some of the tools that LegacyWise provides you as ambassadors, and then we'll pick up any lingering questions you may have to wrap things up. Um, so again, tools that we provide include the training that we've just done here today. I would imagine there's more training to come on this and other topics. That's just something that we're committed to, ensuring that you all feel educated, equipped, and empowered, again, to do the work that you're doing on the front lines. We also have the Ambassador Handbook, where we do address this topic related to legal related questions. We do have I mentioned the Just Law New Hampshire arrangement. There is a Just Law Maine as a part of the work that I'm doing with LegacyWise. We also have a network or a database of sorts that we've started to develop through Christian Legal Society, where some of the attorneys that are affiliated with CLS, we've identified them by state and then by contact information. And so if you're sitting in, Pennsylvania and you say, well, gosh, I just don't know any attorneys in this area. So every time I'm talking to participants, you need to go talk to an attorney. The next question they ask is, well, who would you recommend? And then you say, I don't know. And that doesn't feel very satisfactory. We do have this network that we're trying to start to build up a little bit to give you at least some information that can give you something to provide as far as those kinds of questions when they arise. And then lastly, we just really encourage you, please reach out. Anytime that you come across something that you feel it's just sort of gray area, you're just not sure how to handle, Again, it's okay to say, I don't know. Let me find out. And then reach out to Jake. And then Jake can reach out to me, can reach out to Fred, others. We can try to get information compiled and back to you. And it's always great when you can feel like the hero in the workshop. I get it. I've run workshops. No one likes feeling like, hey, I have to say I don't know, and it just sort of sits in the air and kind of doesn't feel very satisfactory. But in the end, it really is the best as long as we close the loop and follow up with those people afterward. And that's where, again, reaching out to us can be, a helpful way to do that.
From a pragmatic aspect, at what point do you pause the workshop? Like, like, do you get them to finish their documents and then say this specific issue is where you need to address it, go address a lawyer and then fix the documents later? Or do you actually even pause the workshop and return later once they have that question finished?
Right, right. So, of course, it depends on the type of workshop too, right? If you're in a
Yeah.
group workshop, you don't want to necessarily pause the entire workshop for everybody and have to
Mhm.
stop. If you're in a one-on-one workshop, you might have a little bit more latitude to do that if that were in fact needed. If it's a group workshop scenario, as I understand it, at least from when I've done them, you're able to still advance through all the rest of the questions and get everything done as far as you can. And then the system notes the questions that are still unanswered and need to be addressed by the participants. So they'll have that opportunity to go back, as you say, and either update their answer, provide an answer, change their answer, what have you.
I'll add two things to that. So one thing that I'll do is most of the folks who are sitting in one of our workshops, whether it's a group or a one-on-one, right, these documents and this process is going to be very applicable for them, even if their situation has a couple more customizable circumstances, right? So I'll reassure them in one way that um, even if these documents, once they're completed, need some customization, whether it's through just law or a local attorney, right? They've established the foundation, and they've done probably 95% of the work that an attorney is going to come in and maybe put a small piece of custom language in there, which is probably going to be significantly less than going through the entire process with that attorney. And then the other side of that too is it's a 1 year, 100% money back guarantee. So with that person, maybe, I mean, and you could mention this during the midst of a group workshop because it's valuable knowledge for everyone. But perhaps if this person, they come to the realization that, you know, this isn't detailed enough, right? LegacyWise doesn't encompass enough for my needs. Um, we are very happy to refer them out, or if they go to a private attorney, reassure them that you don't need to pay for this twice. We're going to give you back your money, especially if you go out and you see that we just don't fit your need, right? So those are just two conversations that you can have to reinsure those folks. Oh,
Oh, you're on mute.
I have a quick question. Can you all hear me? This is Mika. Hi.
I mean, go ahead.
Hi. I just have is there any standard disclaimer language that we have access to as an ambassador that we can reference like in our materials and stuff?
Yes. Well, and Jake, I believe, I mean, at a minimum, the user agreement disclaimer
Mhm.
could serve that function, even to the extent of an ambassador if they want to use that at the beginning. I know from my own experience, it's one of the first things that that I've raised or Jake and the ones that we've done together, we raise. However, I don't know that we give like a scripted way to do
Yeah,
that. I think that might be what Mika's asking. And
that is.
do
Yeah,
we
it is
have
kind of, yeah, that is what I'm seeking because I am kind of trying to update my website and I wanted to list this as a service that I provide, but I wasn't sure on how it to be, like just making sure the language has the appropriate disclaimers on it.
Yeah.
right.
So if you're looking to add content, I mean, one of the most straightforward things is that number one from the user agreement that's really boiled right down to to most plain language that you could probably make it. The other part too is like in the midst of a workshop, the introductory PowerPoint presentation, there are slides in there that just come right out and say, listen, and you're going to be obviously teaching this to the folks. Like I'm not an attorney. It says that right in there. We don't do tax preparation. We don't do Medicaid lien. And those are in that presentation because those are some of the most common things that people are going to be looking for. Or well, not most common, but they're just things that come up, especially in the conversation of estate planning. So, but if you're looking for something a bit more scripted, I'm happy to put something together in that realm. But I'd heavily lean on that user agreement piece and just format that for general viewing, right? Instead of
Right.
I so and so agree here, right? It could just be more generalized. Good question. Thanks.
Great. Other questions? Well, thank you all so much for making the time out of your busy schedules to join us for this today. We hope it gives you a little bit more information and insight, just gives you some good reminders and parameters. And then ultimately, again, we want to make you feel confident. This is something we can do. It's allowed to do this. There's no reasons that we can't do what we're doing. It's just really a matter of making sure that we understand where the lines are drawn and make sure we don't cross those lines in the work that we do. But we're so grateful for each of you and what you're doing and the ways that you're trying to help so many do these estate planning documents because in the end, it's more important people get these documents done than anything else. And we're grateful for the work you're doing to enable that.
Yeah. Real quick, I just wanted to mention if there are other areas that you feel you could benefit from another brief instructional like this, please don't hesitate to send that out. Common questions that you come in. If you see a trend of, hey, I have a lot of people asking about long-term care, right? Maybe, and we'd like to be able to provide some more answers on this or something, outside of the realm of legal advice or, like Mike had mentioned, just understanding where someone's coming from, right? And having that general knowledge. So you guys run into anything else?
Yeah. I think one thing right off the bat that I've heard a couple of times from young couples is um, that idea of creating a trust in the will package. So rather than going with the trust document, if they want to do a will but want to have a trust that, like a testamentary trust, um, what's that whole process look like? And in doing some research on my own, I see that if you have a trust set up for minor children, the state, at least here in Pennsylvania, the state gets involved in monitoring that on a regular basis. So it can really be, it could be a headache. So I'd love to know a little bit more because from what I understand about spray trusts, which is very little, that there are differences between spray trusts and testamentary trusts. So, I mean, that kind of a thing. What's the best setup for young couples that want to establish a good pathway for funding their kids through adulthood in their estate documents? I think that would be an awesome thing.
Yeah. Thanks, Mark. I wrote that down and that could be certainly something that we can talk on. So again, not to eat up too much time. If there's any other ideas that come in, thoughts, this is a good time, right? This is good training. So thank you all.